And unmute yourself. All right. Do you swear to tell the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, Your Honor.
Thank you. You may put your hand down. Sir, I understand you are in South Carolina, and so
That's correct, Your Honor.
we've agreed that you are here on Zoom, so you are therefore in agreement that you are not standing next to your attorney. Is that correct?
That's correct, Your Honor.
So if you need to speak with her at any time, let me know and we'll put you in a confidential breakout room, okay?
Yes, Your Honor.
All right, and this is a final pretrial, correct?
That's correct, Your Honor.
Has there been an offer?
Yes, Your Honor. This case was over at the annex, and we've given the same offer numerous times over at the annex on the record. That plea would be to an added count of felonious assault. We would be dismissing count 2, the assault strangulation, and count 3, the criminal sexual conduct in the second degree. There would also be an agreement, Your Honor, to HYTA deferral as well as a Cobb's to no upfront jail. The defense has rejected that offer numerous times at this point, so I believe we're ready to go to trial.
Was that Cobb's from me or from the other judge?
It was from Judge Kennedy.
Well, that doesn't matter. That's void. Let's not hear about what Kennedy does, but I would be agreeable to that,
But it's been rejected multiple times at
Okay.
this point.
well, okay. So is that full, fair, accurate, and complete?
It is, Your Honor. I've discussed the offer with Mr. Liddell multiple times, and he would like to go to trial.
Is that correct, sir?
That is correct, Your Honor.
And did anyone force, threaten, or coerce you to make this decision?
No, Your Honor.
Did anyone promise you anything that caused you to make this decision?
Can you repeat? I'm sorry, it cut out.
Yes, did anyone promise you anything that caused you to make this decision?
No, Your Honor.
This decision has been made of your own free will
That's correct, Your Honor.
after you've discussed all the issues you wish with your attorney?
Yes, Your Honor.
And you've been satisfied with the representation of counsel?
Yes, Your Honor.
And have you taken any medication, used any marijuana, alcohol, anything at all yesterday or today?
No, Your Honor.
Are you supposed to be on medication you're not on?
No, Your Honor.
Any sign of fever, COVID, or other illness?
No, Your Honor.
Court is satisfied. We'll move this on to the trial docket. We have a trial date.
Yes, Your Honor. Looking at defense's docket, I believe the next date that would be available for all parties is November 6th.
All right, so, sir, will you still be in school November 6th?
No, Your Honor. I'll be graduated in May.
All right, and sir, you understand that with the plea agreement, you would be earning a non-public record, but if the jury finds you guilty of any of these, you could be a registered sex offender, you could end up in prison. You would not have the option for a non-public record because my hands would be tied, even if I wanted to do that. My hands would be tied. Do you understand the risk that you're taking?
Yes, I understand, Your Honor.
All right, this is moved on to the November 6th trial docket. I trust that meets with your schedule, counsel.
Yes, it does, Your Honor.
All right, thank you very much.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, Harry. I'll be in touch. Thank you.
Where did you transfer, sir?
This is docket 26, 598 FH.
Your Honor,
Yeah.
he's got to come out from.
Oh.
Sorry, thank you.
Counsel, you attended the meeting this morning?
I did, Your Honor. Thank you.
I figured, just wanted to ask. Thank you. This is docket 26-598 FH, 25-4861 FH, and 24-836 FH. People of the state of Michigan versus Travis Lee versus counsel, your appearance for the record.
Thank you, Your Honor. Randall Berman on behalf of the people.
Good morning, Your Honor. Jacob Sarge, the fourth assistant public defender here on behalf of Mr. Verser. Mr. Verser's present at the podium. He's standing by.
Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, ma'am.
Thank you. Put your hand down. Taking any medication yesterday or today?
No,
Are you supposed to be on medication you're not on?
no,
Any sign of fever, COVID, or other illness?
no.
And I understand you've had multiple opportunities to talk to your attorney, including today.
Yes,
And there's a final pretrial. And two of the files, one is just a pretrial, but I suspect there was a global offer. Is that correct?
Not yet, Your Honor. There's a new case that just happened March 3rd that was waived yesterday, and then there's an older case still in district court to come up, so that'll be a total of 5 cases. What Mr. Sartz and I have been discussing is a possibility of, well, Mr. Sartz, I believe, is going to refer the defendant for a specialty court, and I have no objection. We wanted to address his bond on the record and have it revoked back to
Didn't I already revoke it? Oh, you wanted to change the revocation
to
date?
March 3rd, so he gets credit from the time he's been in custody for that new charge.
All right, bond remains revoked, but it will relate back to March 3rd,
I don't know.
2026.
Yes.
Okay.
I'm not sure that the court had. I know that the pretrial services sent a bond violation form on Monday, I think it was. So I don't know if Your Honor had a chance yet to review that. So we just want to make sure we had that on the record.
I don't remember if I signed multiple, all my signings up to date, so I suspect it's signed, it will be in your inbox.
So we're on the record on all 3 of these files, revoking his bond back to March 3rd. I think that covers it. And then we will keep the court informed as to the progress of what the other steps we're taking.
So are we looking at a sobriety court situation, drug court?
Drug court, Your Honor, yeah. They have a bit of wait list right now, but we'll get started on the application paperwork for them. We'll try to get them screened. And then I anticipate that process is going to take a couple months, but we already have one case that's on its way up right now as we speak. We have a second case that's set for a preliminary examination next week. So we need probably a couple months to get those 2 other files situated up here anyway.
What are they doing these days in district court? Do they give you a pretrial date?
We have a probable cause conference and a preliminary examination date. Mr. Verser waived his preliminary examination on charges out of the 55th yesterday. Mr. Berman and I have another case that's at the district court stage. It's scheduled for next week. And
So assuming they bind it over, are they giving you a pretrial date on my docket?
no,
They're not.
no,
Okay.
circuit court arraignment date, Your Honor. It's usually
Or the
set.
circuit court arraignment date, so can we, and I assume that's gonna be waived,
The circuit court arraignment is waived automatically, yes.
so can we use that date as a pretrial for all, or a status conference or something for, is that enough time for?
I'll defer to Mr. Sartz. I don't believe it is.
Well, can I give you, you know me, I do not like to adjourn without a date,
Let's
so can
for
we-
a status conference or pretrial or update of some kind, and I'll defer to Mr. Sartz on the link.
so like in May?
Yeah, that should be plenty of time, Your Honor.
Okay. Then if he is accepted, just set it in front of me or give me the paperwork to sign, and we'll just move all the files over. So we won't use the docket time, is that all right?
Sounds good, Your Honor. Thank you.
So how about,
May 13th, I'm being told is the date, Your Honor.
May 13th, okay, May 13th at, let's just do May 13th at 9:30.
Thank you.
And I made a note, it should be on all 5 cases, it'll be a status. I'm gonna just go put drug court. So I know why we're meeting.
Thank you, Your Honor.
Please, if the paperwork's there, I'll sign it and transfer them, and we'll save the time on my record, all right? Getting what you need over in the jail?
yes, ma'am.
All right. Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
I never received that order in retrial. I can phrase, but what is it based on?
Well, files.
Just hold until I get it.
It won't matter.
I mean, I can change the spot now, but.
What you just witnessed was a courtroom where the weight of serious criminal charges hung over every procedural step, and where two very different paths were laid out before two very different defendants. In the first case, a defendant facing felonious assault, assault by strangulation, and second-degree criminal sexual conduct was offered a deal that could have kept his record non-public. No upfront jail, a HYTA deferral, a genuine lifeline. He turned it down, repeatedly. Now, with a November trial date locked in, the judge made the stakes crystal clear. If that jury returns a guilty verdict, he could face prison, sex offender registration, and a future forever altered. The offer is gone. The risk is real. In the second case, Travis Lee Mercer stood before the court facing 5 separate criminal files, a complex web of charges, I-bond violations, and a new arrest as recently as March 3rd. But instead of a direct path to trial, both sides signaled something different. A referral to drug court, a system designed not just to punish but to rehabilitate. The judge, methodical and forward-thinking, set a May status conference, determined to keep every file on track and every outcome within reach. 2 cases, 2 crossroads, one system doing what it was built to do: weigh consequences, preserve options, and demand accountability at every turn. Because the choices made inside that courtroom don't just affect the people standing before the judge. They ripple outward, into families, into communities, into futures not yet written. If you found this case as eye-opening as we did, hit that like button, drop your thoughts in the comments, and subscribe for more real courtroom breakdowns, because justice never gets old.